Good afternoon, everyone. Thanks for joining us for this exclusive Club 1865 webinar. I'm Amy Rizzo. I'm the marketing manager of Kelleher and Holland, and I'm here to introduce our hosts today. And they're very excited to talk to you about a unique and time-tested estate planning strategy that can reduce your capital gains taxes. So you may have questions during this presentation today, and if you do, just type them in the Q&A question box located in your Zoom control panel, and we will address them at the end of our webinar today. So we have a lot of brain power online today. Our three speakers have decades of experience providing tailored estate planning solutions to individuals, families, and business owners. First off, we have Andy Kelleher. He's a founding member of Kelleher and Holland, and he has an advanced law degree in taxation and is also a CPA. His concentrations include trust and will planning, corporate governance, mergers and acquisitions, exit planning, and asset protection. Bob Holland is also a founding member of the firm and is also a CPA. And Bob focuses his legal work on estate, gift, and succession planning, taxation, asset protection, corporate transactions, and business planning, and commercial real estate. Ed Morrow is the co-chair of the estate planning and estate and trust administration groups at the firm and is nationally known for sharing his depth of knowledge via numerous articles, seminars, and webinars, and is author of the foundational resource that is used for the Certified Trust Financial Advisor designation, as well as being a fellow at the American College of Trust and Estate Counsel. So with that, I will turn it over to Andy to get us started.
Well, thank you, Amy, and thank you everybody for attending today. And getting right to the topic, and what's important is today we're talking about upstream support trust planning. And it's a multi-generational tool that can be used for you and your business. So a lot of times in estate planning and tax planning, we're always talking about other people, benefiting the kids, benefiting a surviving spouse. But this planning is neat because it focuses on capital gains step-up planning that benefits you and your family, while you're alive. So you actually can benefit from this. So and the general idea of this is that it's a strategy by using usually older people or sicker people's exemption, or less wealthy people in your family, using their estate tax exemption in order to obtain a step up in basis for you and for assets that you own. And importantly, the planning involves you and your family, like your immediate family, like maybe it's a husband and wife scenario. You and your wife or you and your husband will be maintaining the use and possession of the asset that's being benefited by the capital gain planning, usually in trust. So with that, I'll turn just with that general idea that it's benefiting you. You're not using, use and control of your asset, and you're using the estate tax exemption of another person to obtain a step up in basis for capital gain purposes. I'll turn it over to the group.
Okay, well, Andy, I'll go ahead and step in, but I think one of the things that people don't realize is that the applicable exclusion amount, or how much you can leave at death without estate or gift tax, is also can be what I would call a basis increasing coupon. I mean, everybody's got a coupon to pass 13.61 million or however much the applicable exclusion amount is at the time of their death, or that's how much they can pass and step up in basis without any any estate tax due. At least on the federal level. We got a little bit different for Illinois. But what we're trying to do here is not waste the basis increasing coupon that somebody may have if somebody, you've got an older relative in your family that doesn't have a taxable estate. So when we're talking about upstream planning, or UST planning, as we refer to here, we're using an irrevocable trust for the family, just like what some people may have heard the term SLAT, spousal lifetime access trust. It's a SLAT, but it's got extra benefits to it. An irrevocable trust for the family, spouse, children, grandchildren, etc. You can also add older family members as beneficiaries. And oftentimes with people living longer these days, somebody might have a mother-in-law, father-in-law, somebody that they're helping out financially in the family that's still living, and they may be in their 80s or 90s. It's not uncommon. But those older beneficiaries can also be, beneficiaries of a trust, and you can give those particular beneficiaries certain powers in the trust that trigger estate inclusion in, in other words, inclusion in their estate. And that estate inclusion causes a step up in basis at their death. Now, if my father-in-law or mother-in-law, or that I name as a beneficiary, if they're independently wealthy and they have $50 million of their own, well, I'm not going to give them a benefit, some kind of power that triggers estate inclusion, because that'll cause estate tax. But if they have less than 1 million, or less than $4 million, or anything under the applicable exclusion amount, typically, we can give them certain powers over the trust assets that cause a step up in basis at their death. So what we can do is, if we don't know what the applicable exclusion amount is going to be at the time of death, you can put a cap on the powers that create the inclusion. And we can also kind of put some curbs on the power so that, it doesn't cause the assets to go somewhere else, for instance. And so this kind of power that we're including in the trust has to be carefully drafted. But if it is, what we've done is we've not wasted the older beneficiaries and older relatives' applicable exclusion amount. We haven't wasted their basis increasing coupon. And if we go to the next slide, you can see how powerful this might be, particularly when we're using leveraged assets. So a lot of people, some people on this call probably have real estate assets. So let me just use a really quick example of a settlor, the taxpayer that's got an LLC that's got $10 million of real estate. And like a lot of real estate developers and owners and investors, there's a lot of debt associated with it. Here we've got $7 million of debt. So what's the net value of this LLC? $3 million, right? Well, over time, the basis gets depreciated down, and practically down to the value of the land, perhaps sometimes, if they've held it long enough and done 1031 exchanges, and the basis might be $1 million. That's not uncommon. Well, a lot of people think about, oh, well, what about if I gift this to a trust? But let's not gift it to an ordinary spousal lifetime access trust that's so common. Let's gift this to a trust that includes not only my spouse and my kids, but maybe my parent, or mother-in-law, father-in-law, or maybe an uncle that I help out or something. And that uncle or aunt or mother-in-law may only have a few years to live. And when that party dies, we can put powers in the trust that causes estate inclusion. And guess what happens to the basis of the assets in that estate? Now, we've added $3 million to their estate, the $3 million fair market value. But if they can add $3 million to their estate and not pay estate tax, there's no estate tax negative. All we've got is an income tax positive. In other words, the positive result of getting a step up from $1 million to $10 million of basis when the parent dies. That additional basis either totally wipes out any capital gains if we sell the asset, or if it's depreciable property, guess what the depreciation schedule starts at? $10 million again. So we've done something that's really important. Andy, you mentioned that a lot of estate planning is, trying to save estate tax when husband and wife die. This is saving income tax while husband and wife are still living. It's saving it if the parent dies, for instance, in this particular case. And we're saving money not only by avoiding capital gains tax, but even if it's not sold, if it's depreciable property, we're saving income tax currently because the depreciation schedule is based on the $10 million of adjustable basis. And by the way, this is just using relatively small numbers. I've dealt with cases in the past where we've used even larger numbers with larger leverage and larger amounts. But you can see, saving $9 million of capital gains tax, $9 million of additional basis, can be extremely valuable to the family.
So Ed, we're looking at the scenario: the settlor, maybe the business owner, maybe one of the members of 1865, has this type of property, and they have, let's say, a mother, who's worth $1 million down in Florida, where the most, and she doesn't have any creditors. And the idea is that they can set up a trust for their family, maybe, and including the mother in there, giving the mother these special powers. And then when the mother passes away, the settlor or the 1865 member, gets a step up in basis for that asset inside that trust, so that 1865 members' family can enjoy a big capital gains benefit. If they sell that property, they're going to avoid a lot of capital gains planning by this. And mom's got to be happy about that too. Although she passed away, she's got to be pretty happy about helping out her family. And because this doesn't cause any estate tax problems and it's only upside for capital gain, yeah, it sounds like a pretty darn good idea, and something that we've not just a darn good idea, but something that's worked many times. And is that a pretty accurate description of what's going down here?
Yeah, absolutely, Andy. And it's something that it's taken a few years. I mean, this idea has been around for a while, but it's taken even myself. I've written a lot of articles about this in the past, but it takes rethinking of how you look at the estate plan. You have to look upstream and downstream, generation wide, among the entire family to. And even though the idea kind of sounds a little bit distasteful at first, there's a lot of families that they communicate pretty well with their parents and kids and things. And, I found that they like to kind of help out their family financially anyway. They're already kind of helping pay mom's bills a little bit or, a little bit here and there. Making that gift from the upstream trust is, fine. They don't have any problem with that. And mom and dad, do they want to, their kids and grandkids to get better tax results and save money? Of course they do. So, even though it sounds a little off-putting at first, once clients kind of talk about this, and even when they tell their mom or dad about it, they're gangbusters for it. And I've not found one client yet. The only time I've had a client, Andy, that didn't do this is when there was, really bad blood and dysfunctional kind of family situation.
Right.
But in many situations, it works pretty well.
Yeah, I've had the similar experience where you have a family maybe where there's siblings that don't get along, or a rarer case where the parents doesn't get along with the child setting up this plan, and they just don't want any fuss. If mom and dad
Right.
pass away, they'd love to have the capital gains step up, but they just don't want to deal with any fuss. But that's non-technical things. Those are family emotional things as opposed to what works for tax planning, and this definitely works.
And let me mention too is sometimes an alternative sometimes discussed is, well, Ed, why can't I just give this $3 million of LLC interest to my mom or dad directly without using this fancy trust setup? Well, you don't want to do that for several reasons. One, it exposes it to their creditors. Uh, Two, maybe they leave it to your brother and sister that they like more than you, right? Or they get remarried, or who knows what many other things they give it away to their church. So using the trust prohibits that from happening. You put some curbs and bells and whistles and things like that on the trust, and that keeps the control in the family and prevents that, whether it's inadvertent or intentional, disinheritance from some action of the parent, and it protects it from creditors as well. So there's any number of different reasons why we don't want to just do an outright gift. We want to use a trust for this kind of planning. Another question that I get, Andy, is sometimes people say, well, can I just do this with a revocable ordinary trust that I have? Revocable trust, and it's not quite as certain. We usually like to use these with irrevocable trust for much more tax certainty. I know one attorney that tried to do it with a revocable trust, and who knows, more power to him. Maybe he'll get lucky and he'll have it work. But we usually try to be a little bit more cautious about that, and it's more uncertain. We like to use an irrevocable trust. But we find that most people that have this kind of wealth with large appreciated property, they like to use irrevocable trust for asset protection and estate tax savings anyway. So just adding these additional, clauses to the trust for extra capital gains tax benefits is just a no-brainer.
Along those lines, Ed, what if I've already done both revocable trust planning, irrevocable trust planning? I've already created maybe a slat for my wife. She's created one for me. We've used up most, if not all, of our, gift exemptions. We already have an asset like this in an irrevocable trust. Are there ways to maneuver and maybe update an existing plan to incorporate this planning?
Yeah, it's going to be on a case by case basis, Bob. I mean, of course, our firm builds in a lot of flexibility into our irrevocable trust with things like trust protectors and the ability to add that. So when somebody comes in to me and says, "Oh, really like to do this. I like this idea. Can we just amend this slat that I set up?" We just have to read the document, right, and see how possible is it. Is it possible within the terms of the document? What you'd have to do in many cases is actually add a beneficiary, and that's not a common thing that you can just do without explicit provision in the document or going to court or something. So case by case basis, but it may be very possible. There's a lot of flexibility and ways to skin a cat, as they say. And so we could probably get it done, but it's got to be case by case. You got to review the trust.
Excellent.
Ed, looking at the special power that we would give, let's say, in my scenario, mom living down in Florida, what happens if I set up this type of trust for my mom and my mom and I, for some reason, have a falling out? My mom doesn't like me for one reason, and she's like, "Hey, we get into trouble, and I don't like her to have this special power over the assets that would give me this great capital gain benefit, but I don't want to have. If what happens if I have my mother has this power and I don't want her to have it, how can I fix that or alleviate that?"
Well, yeah, there's a couple different ways to do that. First of all, we start off with making the power hard to exercise to the detriment of the family. So you typically have it so that, Andy, you would say, give your mother this power, but you don't know, she could get remarried to some guy that doesn't like you, right? Something like that. So you say, hey, you know what, mom, I'm going to give you this power over some of the trust assets, but only can be exercised with permission of my buddy Bob Holland. If you trust Bob not to allow something nefarious to happen,
I would. I would trust Bob.
and she can't do anything without that extra consent. And you can more than one party's consent. It has to be somebody who's not a beneficiary of the trust. Like you can't name your kids, but other than that, you can name pretty much anybody else in the world. Three different people whose opinion and judgment you trust, and if their permission isn't granted, mom can't do anything about it. And so that's one way to do it. Another way is through having some kind of trust protector type power to remove that later. I kind of prefer the first because you still get all the tax benefits. Because the IRS says if you put these certain powers, they still trigger estate inclusion, even if you have this non-adverse party consent of this friend or colleague or whoever that you might appoint. So debt free. And in fact, if you're super conservative and cautious, you could put more than one method in there. So we could do both, like have that consent of multiple parties plus the trust protector power as well.
I'm also thinking as far as if there's any downsides to the planning, Ed. So one of the ideas would be what are the downsides, and I know the answer to a degree right here. So with the idea, I do know the answer, but what are the downsides, and as far as a tax reporting strategy, how do we avoid the downsides of getting the step up and reporting that properly? So are there any downsides, and how can we alleviate any downsides with proper tax reporting?
Yeah, most of the downside risk would be, we've already kind of talked about some ways you can alleviate problems with, you have a trust protector that can amend the clause that causes the inclusion, because we don't know what tax laws could change, right? We got an election coming up this year. Who knows who's going to be in power next year? What's the Senate and the House of Representatives going to be? Who knows what the tax law can be a year from now? So what we do is we have a protector clause that can amend the particular clauses that cause inclusion, and then we can take a conservative reporting status as well. And so between those two things, we can always be pretty protective of clients and pretty assured that we're going to get a good result.
Well, with that, I'm sorry, Bob. Go on.
One last thing was, if let's say I use a parent, for example, so I do this planning, I take an asset, real estate with low basis that I've depreciated over the years, I put it in a trust, and I use my mom, right? And I give her this special power over this to get this planning. What impact, if any, does it have on her income tax reporting, Medicare premiums, or things of that nature? Does it create any extra red tape at her level?
Yeah, that's a great question, Bob. We would typically draft these trusts so that they're not counted for a beneficiary for Medicaid purposes. It's called a third-party discretionary trust. Wouldn't be counted in their name or make them disqualified for Medicaid or anything like that. It would still be taxed to the settlor who's setting up the trust, as what we call a grantor trust. And so that means it's not complicating 1040s or tax reporting whatsoever during lifetime. We can be a little bit clever and make it an out-of-state trust after the parent's death. So right now, when you're in Illinois, for instance, you're kind of stuck with paying Illinois income tax on every last dime of income, even capital gains, right? Whereas when you have a trust that's set up, if my mom was in Florida and at her death set up a new trust for me, she's the settlor. It's a Florida trust, not an Illinois trust, and I got around Illinois income tax after that, as long as it's not source income of a business or something like that. So there's a lot of different things that we can do to prevent uh, negatives and actually cause additional positives too. So kind of depends on a lot of the different factors, what state the beneficiaries would be in too, how we could draft that.
That makes sense.
With that, we'll get towards conclusion. And the bottom line of this planning is that this planning has very, very significant upsides for a family, and the downsides are really negligible. And with good planning, this type of step up is available. And I think this is going to be something that's going to become an even more mainstream. Although we've been doing it internally for many years, it's going to become more and more mainstream and known. And we just wanted to make sure that our friends at Club 1865 are aware of the planning because it's so powerful. So with that, we'd like to say thank you to everyone. And this will be recorded and shared with the other Club 1865 members. And we thank you all for attending.